Within 3 years.
That's very quickly.
We have mediation before the Ontario Municipal Board in March of next year. Several days we've got appeals from both the development community and residents groups who weren't happy with it. I think we're looking at doing much more closely to resolving some of those issues. If we don't resolve those issues through mediation in March, we have a firm hearing the last week in August. Hopefully we'll have a decision sometime in October of next year, and that means we can start implementing bylaws after that, but that just means the start of study. So the good news is it's coming, bad news is not for a year.
Okay, and thank you, Jennifer. If everyone can give her a round of applause. So we'll keep John Andrzejewski here. He's doing a lot of the planning applications in the city, so he's not getting off as quickly as he thinks. And also we'll hear a few words from Brendan O'Callaghan about the OMP.
Thank you, Councillor. My name is Brendan O'Callaghan, and I have indeed done over 400 Ontario Municipal Board hearings, and I'd be quick to point out that I actually won some of those. Nobody ever wants to have to follow Jennifer Keesmaat as a speaker, and yet I find myself doing just exactly that. I'm going to run over some very broad brush principles about the Ontario Municipal Board, what it is, what its authority is, what its relationship to the City of Toronto Council is, what its relationship is to me as the city's lawyer, and what it might mean for you should you wish to participate in the hearing. The Ontario Municipal Board is a quasi-judicial tribunal. It is given authority by its own act and by a number of other acts, including the Planning Act, which I've already explained in response to some questions. Gives the developers and the city, for that matter, very strict timelines within which to file applications, consider development applications, and then appeal if those applications are either refused or are not decided upon by City Council. And again, it's a bit of a blunt instrument. The Planning Act applies throughout the entire province, and so the City of Toronto is bound by the same rules as Timmins, and rules that may not be particularly appropriate for City of Toronto are the ones that are established for other parts of the province. The other thing that's worth noting is the province has established many of the guidelines, the rules, and the policies that the Ontario Municipal Board must consider in making decisions. And Jennifer has talked about a number of those. There is the growth plan, which is something that gives every municipality in the province density numbers with which we must accommodate. In other words, they tell us how many new residents we have to account for, how many new neighborhoods have to develop, how many new apartment buildings have to be established. And so you've got, on the one hand, provincial policy statements, growth plan, and to a lesser extent our own official plan establishing areas for growth. Now the corollary of that is the good news, which is that your neighborhoods, our neighborhoods in the City of Toronto are not to intensify. In other words, single-family residential houses are not to intensify. So where is the density going to go? It's going to go into apartment neighborhoods, it's going to go into industrial areas. And again, it's being given to us by the province. And so these are the policies and the guidelines that the Ontario Municipal Board must consider when an application comes before it, whether it be on appeal or otherwise. And so when people attempt to vilify the Ontario Municipal Board because perhaps of our success rate there, or because the Municipal Board is always accused of approving things, which they very often do, it isn't that they're pro-development necessarily. It is that the policies that guide them, and frankly us as planners and lawyers, is pro-development. And the challenge is to understand going in what the likely outcomes are at the hearing. And again, participation is important. So when you get involved in a process, understand that the end result is not going to be Nothing. It's not going to be scorched earth. It is how can I participate in the process and improve that development such that its impact is reduced or mitigated for me. In other words, should the height come down? Should the density come down? Should the fences be taller? Should there be more landscaping? Should there be another street added throughout the development process? That type of thing is what the Ontario Municipal Board is very anxious to hear from both residents and from the city. As I said, I get my instructions, and my colleagues in city legal get our instructions when city council makes a decision. Sometimes we are in support of applications, sometimes we are not. I can tell you that some of the big successes, frankly, for the city have been at the Ontario Municipal Board. We've won a very good number of hearings. Some of the city's big, important citywide initiatives have been approved by the Ontario Municipal Board, so I'm not as critical of the board as many are. The board also has jurisdiction to sit in judgment of the Committee of Adjustment. City legal does not have standing authority to attend on those. If council makes a decision to refuse a zoning application or an official plan amendment, then I or one of my colleagues go to the Ontario Municipal Board in support of the council decision. The Committee of Adjustment, as many of you may know, makes thousands, literally thousands of decisions about what they consider to be minor variances every year, and that includes everything from height of a building to setbacks to the amount of landscaping, and we don't have authority to go on those. If the councillor directs us to go in support of a decision or in opposition to a decision, and council accepts that, then obviously we will do that. But that is the exception to the rule. And so to the extent that you've had experience at the Ontario Municipal Board on a Committee of Adjustment appeal, you may often find that the city solicitor is not there. And that is because we don't have standing authority. And to the extent that you think it's important that we be there, then you're welcome to speak to your councillor about that, and he can arrange to have that happen. Having said that, a lot of Committee of Adjustment decisions are truly neighborhood disputes, and they don't involve sort of broader city policy. Everybody has a right to go to the Ontario Municipal Board and participate in the proceedings. There are different types of status within which you can participate. You can become a party, which has greater responsibilities, but it also has greater rights. A party to a board hearing requires you to be there every day. It requires you to either be an individual or an incorporated ratepayers group. The city, of course, will be there as a party if it's a rezoning appeal. The developer, of course, will be there as a party, and they'll be there every day. The other alternative is a less onerous alternative. It's called a participant, and it means that you can show up when the board would like to hear from area residents, and you'll be sworn or affirm an oath on your conscience. You'll go on the witness stand, and you will let the board know what it is that you have observed about the application and what you would like the board to do with the application. And again, the closer you are in proximity, your house is to the proposal, I think the more weight it will be given, the more of an impact that it might have upon you. I think the more weight that evidence will be given. The municipal board historically is interested in things like shadow onto your property, overlook onto your property. They're interested in traffic, albeit if traffic is an issue, you can be sure the developer will have a traffic engineer there who will say everything is fine. I can tell you that in my experience, I love engineers. The problem is they're very, very good at solving problems. And so if you tell them about the traffic, and it is always bad, then they'll engineer a solution. And it often may mean road widening, it might mean rejigging the lights, it might mean adding stacking lanes at an intersection. The problem I've found is that that is a tough element to win a hearing upon alone. We've had much more success when something simply runs afoul of a recent, well-thought-out policy, and I've got planning staff support with me there at the board in opposition. The other thing that I would always encourage people to do is, again, exactly what you're doing right now. You're engaged, you're educating yourselves, you're obviously very well informed about the applications that are going on in your community. Stay involved, participate in that process, and think about things that you can seek from the developer that will improve the process. Because as I've said before, scorched earth or nothing getting approved is a very unlikely outcome. However, significant public benefits are a very likely outcome. What will assist you in making that development more palatable in your community? That means potentially lowering the heights, it might mean more step backs, it might mean a donation from the developer to a local community center, it might mean an addition to a park or a tot lot or a pet park. There are a number of things. Don't be constrained. Use only your imagination in terms of what you would like to extract in the development process. That's what city planning staff do, that's what I attempt to do, and it's my experience that the more participation you have in the process, the more you will extract from the developer and the more successful you will be at the Ontario Municipal Board. Having said that, there's a number of things that the Ontario Municipal Board will not listen to because they simply don't have the jurisdiction, and a couple of them have been mentioned here today. One is school capacity. The school boards have their own legal representation, they have their own planning staff, and in my experience, they have in the past actually sent lawyers and planners to Ontario Municipal Board hearings if there's a capacity problem. But if they're not there, I can tell you that the Ontario Municipal Board will not listen to somebody else giving anecdotal evidence about the capacity of the school. They'll say the school board's representative, they're not here, I'm not going to hear it. It's unfortunate, but that's the reality. The other reality is the board will not hear any evidence about land valuations. Everybody is of the view that something being developed in their neighborhood is going to cause their properties to go down. Firstly, it's not true, and secondly, the Ontario Municipal Board won't listen to that evidence. It's not something that's relevant. The only question that the board has to ask itself is, does the development proposal that is before it represent good planning, and does it conform with all the various policies, the growth plan, the provincial policy statements, and the city's own official plan? And so the more you can stay focused on addressing those policies and those questions that the board will have, I think the more successful you'll be. That's my little 5-minute blurb on what the Ontario Municipal Board is. The people who sit in as the chairs, they're appointed by the province of Ontario. Some are lawyers, many are planners. There's sort of a mixed bag, and like I say, they will always listen to members of the public, and they will be happy to hear any evidence that you may have. If you are interested in participating but you don't want to be a party, and frankly, unless you have a week to sit through a bunch of really excruciatingly boring planning evidence, my advice is that you choose to be a participant, and then you stay in touch with the city's lawyer or the city planner, and a block of time will be allotted for you, possibly even in the community, possibly even at night to make it more convenient, and then you're welcome to show up and say anything you want. The only thing you need to be aware of is that you will be required to swear an oath, and of course that means you will be subject to cross-examination from the developer's lawyer should they have questions for you. And so you just have to be careful and thoughtful about what you say, but in my experience, area residents usually are. So those are my comments for tonight, and I'm happy to answer a couple of questions if there are any.